New Mexico Real Estate Basics, page 26. What are some examples of express written agreements? Listing agreements, buyer-broker agreements, purchase agreements, management agreements, leases, and letters of intent are examples of express written agreements. An express written agreement is any document signed by all parties to the transaction. When is the disclosure made? The time frame varies depending on whether the client is a seller, buyer, landlord, or tenant. Thus, the broker discloses with a seller before a listing agreement is signed. Buyers must acknowledge in writing the disclosure before a buyer-broker agreement is signed or an offer is made. The sellers must receive the disclosure before an offer is presented. The form is kept on file in the listing broker's office and the buyer's broker's office for 3 years. Does the broker duties disclosure include agreements for broker compensation? No. The consumer's agreement to compensate a broker is determined by a brokerage agreement, not by a disclosure. The existence of a written agreement with another party to the transaction must be disclosed, as would any compensation to be received from the other party. Does the broker duties disclosure create any obligations on the part of the buyer or seller? No. The disclosure is simply an acknowledgement that broker duties have been discussed with the consumer. The consumer should sign the document as proof that the broker has made the required disclosure. Thus, the buyer or seller is still free to work with other agents. What is critical is that the disclosure does set obligations on the part of the broker agent. Written authority to provide real estate services may be obtained at this time, but it is not required unless the client chooses to have those services provided in an agency relationship. What about dual agency disclosures? Offices may have a policy permitting dual agency with informed written consent. In a dual agency, the broker must endeavor to remain impartial and not aggressively represent the interest of either party to the exclusion or detriment of the other party. Brokers can act as dual agents only if all parties give their written consent in the form of a separate written dual agency agreement. The possibility of dual agency should be discussed and agreed on before the seller signs a listing agreement or before providing specific assistance to the buyer. If the consumer creates an agency agreement with the agent and agrees to the possibility of dual agency, then a second disclosure is required at the time the agent actually becomes a dual agent. Page 27. What happens if no broker duties disclosure is made? Failure to disclose in writing before the consumer enters an express written agreement is a prima facie violation of license law and rules, and the broker is subject to disciplinary action. However, a failure to disclose does not affect the validity of title to real property already transferred. Are any other disclosures required? Unless a written notice to the contrary exists, brokers are prohibited from accepting undisclosed compensation related to a transaction from any person other than the agreed parties. Also, brokers must disclose in writing when acting in a transaction on their own behalf, on behalf of an immediate family member or brokerage, or on behalf of a business entity in which the broker has an interest. Brokerage agreements. What is brokerage? A brokerage is the office and is defined by the Licensing Act as the qualifying broker, and all affiliated brokers representing the qualifying broker. A real estate broker is defined as a person licensed to buy, sell, exchange, auction, deal in options, lease real property, or offer to do so for others, and to charge a fee for those services. As discussed in Chapter 1, New Mexico requires a license to act as a broker, advertise one's services as a broker, negotiate, collect rents, or seek out prospects for real estate related activities. What are brokerage agreements? Brokerage agreements are essentially employment contracts requesting the professional services of the broker, not the transfer of real estate. Brokerages enter into employment agreements with sellers, buyers, landlords, and tenants. Brokerage agreements confirm compensation issues and determine the brokerage relationship. Depending on the agreement, the broker could be an agent or a principal. In a listing agreement, the seller is the principal client, and the broker delegates the work to agents, affiliate brokers. In a brokerage agreement with a buyer, the buyer is the principal client, and the broker delegates the work to the affiliates. The employment agreement will also determine if the broker is to be an agent or transaction broker of the buyer or seller principal. In many firms, the broker will choose designated agency, appointing a broker as exclusive representative of the principal client. Are referral fees legal in New Mexico? Every year, real estate brokers help thousands of families by referring them to other brokers across the United States. In return for the referral, a percentage or other agreed upon fee is paid to the referring broker. These fees are legal if paid between brokers.